Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the IBC, which is now reshaping the economic landscape in our country. So let us today discuss one landmark case. So this is the case of Indiabulls Asset Reconstruction Company Limited versus Ram Kishore Arora and others, decided on 11th of May 2023 by the Honorable Supreme Court of India. Now, in a batch of appeals filed by Union Bank of India and Indiabulls Asset Reconstruction Company Limited, which is the appellants, against the order of the principal bench of NCLAT, wherein while admitting an application under Section 7 of the IBC, a slew of directions were issued which converted the corporate insolvency resolution process into a project-wise insolvency resolution process. The division bench of the Honorable Supreme Court upheld the NCLAT's order for project-wise resolution and said that if committee of creditors would be constituted for Supertech Limited, which is the corporate debtor, as a whole, it would cause hardships for home buyers. Now let us see the factual background of the case. Now the appellants are the financial creditors of the corporate debtor. The corporate debtor is a real estate company engaged in construction of various projects, which received credit facilities from Union Bank of India in the sum of rupees 150 crores for the development of the Eco Village 2 project. Subsequently, Union Bank of India and Bank of Baroda entered into an agreement, extended second credit facilities in the sum of rupees 200 crores, with Union Bank of India's total exposure being rupees 100 crores. On corporate debtors' default on the loan repayment, the account was declared as an NPA. Thereby, the Union Bank of India filed an application under Section 7 of the IBC, claiming a total amount of rupees 431.92 crores, along with accrued interest. The Honorable NCLT admitted the Section 7 application and directed for initiation of CIRP for the corporate debtor, and an IRP was appointed. Aggrieved by the order of Honorable NCLT, the suspended directors of corporate debtor filed an appeal before the Honorable NCLAT. The Honorable NCLAT issued interim directions for constitution of committee of creditors for Eco Village Project 2, and only the said project to be completed with the assistance of ex-management, whereas other projects apart from Eco Village 2 were ordered to be continued as ongoing projects. Now, the interim directions in the impugned order dated 10th of June 2022 included the following. That is, IRP to constitute the COC with regard to the project Eco Village 2 only, after which the IRP shall proceed to complete the construction of the project with the assistance of the ex-management, its employees and workmen. With regard to the Eco Village 2 project, the IRP shall proceed with the completion of the project resolution and shall be free to prepare information memorandum, issue Form G, invite resolution plan. However, no resolution plan be put for voting without the leave of the court. All the receivables with regard to the Eco Village 2 project shall be kept in the separate account, and detailed accounts of inflow and outflow shall be maintained by the IRP. That all the other projects of the corporate debtor, apart from Eco Village 2 project, shall be kept as ongoing project. The construction of all other projects shall continue with overall supervision of the IRP, with the assistance of the ex-management and its employees and workmen. The promoter shall infuse the funds as arranged by it in different projects, which shall be treated as interim finance, regarding which detailed account shall be maintained by the IRP. No account of the corporate debtor shall be operated without the counter signature of the IRP. And all expenses and payments in different projects shall be only with the approval of the IRP. All receivables in different projects shall be deposited in the account as per RERA guidelines, and 70% of the amount shall be utilized for the construction purposes only. And with regard to the disbursement of the rest of the 30%, Appropriate direction shall be issued subsequently after receiving the status report and after hearing all concerns. The IRP shall obtain approval of the COC, which is directed to be constituted for Eco Village 2 project and incur all the expenses regarding the said projects accordingly. Now, dissatisfied with the interim directions issued by the Honorable NCLAT, the appellants, that is the financial creditors of the CD, filed appeals before the Honorable Supreme Court, essentially challenging the adoption of reverse CIRB by the NCLAT and limiting the CIRP and constitution of COC to only one project of the corporate debtor, that is Eco Village 2. Now let us see what are the observations of the Honorable Supreme Court. The Honorable Supreme Court observed the limited use cases for reverse CIRP, a process not established via the IBC, but a product of judicial invention. This court declined to alter the order made by the Honorable NCLAT on 10th of June 2022, giving reasons regarding the nature behind granting interim reliefs and the special case-by-case usage of reverse CIRP. Citing the cases of Union of India versus Rajgro Impex and others, it held that whilst considering the viability of implementation of any interim relief mechanism, the elements of balance of convenience and likelihood of irreparable injury and prima facie case must be taken into account so as to determine whether the granting or not granting of said mechanisms would cause injustice or irreparable damage to the parties involved. The Honorable Supreme Court highlighted the benefits and protection that such a mechanism would bring for the homeowners, who in other cases would not be able to handle this matter by themselves, albeit being considered to be financial creditors. Further, let's see the court's decision whether the proposition of project-wise resolution for insolvency application under Section 7 of the IBC as adopted by the NCLAT was tenable. The court said that the NCLAT had adopted a particular course while observing that the project-wise resolution may be started as a test to find out the success of such resolution. The result of the directions of the impugned order was that except Eco Village 2 project, all other projects of the corporate debtor were to be kept as ongoing projects, and the construction of all other projects was to be continued under the supervision of the IRP, with the ex-management, its employees, and workmen. Further, the court said that if at the present stage, COC was ordered to be constituted for the CD in displacement of the directions of the NCLAT, it was likely to affect those ongoing projects and thereby cause immense hardship to the home buyers while throwing every project into a state of uncertainty. Further, the court also noted that on the other hand, the other projects were being continued by the IRP and efforts were being made for infusion of funds with the active assistance of the ex-management, but without creating any additional rights in the ex-management. Thus, the court viewed that greater inconvenience was likely to be caused by passing any interim order of the constitution of COC in relation to the corporate debtor as a whole, and it may cause irreparable injury to the home buyers. Thus, the court said that it was not inclined to alter the directions in the impugned order regarding the projects other than Eco Village 2. The court refused to interfere with the directions relating to the Eco Village 2 project, since COC was ordered to be constituted by the NCLAT in the impugned order. However, the court said that any process beyond voting on the resolution plan should not be undertaken without the specific orders of the court. So friends, we see here how the complicated status of the real estate projects in our country is being really tried to be resolved by the courts of our country, especially the highest court, the Honorable Supreme Court of our country. So friends, I trust that you find this both engaging as well as enlightening. So for further insights into such key judgments, please like this video and subscribe to my YouTube channel. So thank you very much for being here today with me. This is Deepika B. Prasad signing off. We'll catch you in the next case. Thank you.